You brought a lawsuit against four different doctors. Doctor number 3, his attorney calls me one day and says, listen, my doctor did absolutely nothing wrong. I'd like you to let us out of the case because we are never, ever going to participate in settlement negotiations in your case. You know what I said to that? Come join me for a walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. Okay, my client sued 4 different doctors in sequence, doctors who had cared for her over a period of 2 years. And now we had medical experts who confirmed that each one of these doctors failed to recognize what was going on with her. And as a result, her injuries got worse and worse, and she suffered very significant harm and disability. Now, as this case is coming up for trial, we encourage all 4 attorneys who represented each of the doctors to join us in a settlement conversation, in a private settlement conversation known as a mediation. A mediation is an impartial judge who sits there and tries to coerce, and I say that gently, who tries to coerce each side to recognize the risks of going to trial and the risks of having a jury ultimately come back with a verdict. And in addition to putting pressure on each of the defense attorneys, this mediator will also put pressure on us to get us to recognize and realize that there are no guarantees when going to trial. And even if we believe we have a great case and we have great medical experts, there is still a risk that, number one, we could lose the case. There is also a risk that even if we win, the jury may find that there is no connection between the wrongdoing and the injury. In that case, we would lose. And even if we are able to show that the wrongdoing caused you significant harm and injury, there is no guarantee that the jury will come back and recognize and acknowledge that your injuries are worth what we claim them to be. In that instance, now the mediator is going to put pressure on us. So now we believed, based upon our medical experts, that each one of these doctors were equally responsible in causing my client's injuries. However, the attorney for doctor number 3 disagreed. That attorney felt, listen, doctor number 1 and doctor number 2 are primarily responsible in this case. My doctor, doctor number 3, had nothing whatsoever to cause this patient harm and injury. And the injuries that she did suffer, she claims, had nothing whatsoever to do with this care rendered by doctor number 3. Now, this was outside the present. This conversation between me and the attorney for doctor number 3 was held in a private conversation on the telephone. And why do I say it was beneficial to have this privately? If this conversation were held in front of all 4 defense attorneys, doctor number 4's attorney would turn around and say, listen, if doctor number 3 is not responsible for this patient's injuries, then how can doctor number 4 be responsible for this patient's injuries? Because we claim that nothing he did caused or contributed to your client's injuries. So if doctor number 3 is claiming that nothing that he did caused these injuries, and everything was based upon doctors 1 and 2 to cause these injuries, then how is doctor number 4 responsible? And that is oftentimes a valid argument to make if the facts support it. Now, in this case, we believe that the argument that was being made by doctor number 3's attorney was a false argument and did not apply. And we had medical experts to support our exact position. But for settlement purposes, it was a very, very interesting argument to make. And now, when we actually had the mediation, the mediator turned to each of the defense attorneys to ask what their position was. They all said they were not going to negotiate. However, doctors 1 and 2 clearly said that they recognized as a problem and that they would be willing to start negotiating, and they did actually offer money. But doctor number 3 and his attorney turned around and says, no, we're not offering a dime. We did nothing wrong. And now, of course, we knew what would happen. Doctor number 4 says, hey, listen, if doctor number 3 is not contributing, then there's no basis for doctor number 4 to contribute as well. So now we had a bit of a standoff. And so what happened? Even when the mediator tried to coerce and put pressure on doctor number 3 and number 4 through their attorneys, they would not budge. And ultimately, we were not successful in trying to resolve the case during this settlement discussion known as a mediation. So what happened then? What happened then is we went to trial. And now we were willing to let a jury decide whether or not doctor number 3 and number 4 were responsible for my client's injuries. So why do I share this information with you? I share it with you just to open your eyes and to help you understand how these types of medical malpractice cases, these accident cases, and even these wrongful death cases work in the state of New York. I realize you're watching this because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.